Welcome to this video on the Regents of the University of California versus Bakke case, presented by the World Affairs Council of Austin. The 1978 case started in 1974 when Alan Bakke sued the University of California Davis School of Medicine. Bakke, a white applicant, challenged the special admissions program that reserved 16 out of 100 seats for minority applicants, arguing it was unlawful racial discrimination. This is the actual trial-level case data. UC Davis Medical School used a dual-track system, regular admissions and special admissions with 16 reserved seats. Bakke's academic scores exceeded those of many special program admittees. He sued, alleging violations of the Equal Protection Clause and anti-discrimination laws. This case highlights the conflict between remedying past discrimination and ensuring individual fairness. Bakke filed suit in the Yolo County Superior Court, which ruled the program unconstitutional. After the California Supreme Court struck down the program and ordered Bakke admitted, the Regents appealed the case to the U.S. Supreme Court. Bakke's theory was that the special program was an unconstitutional quota system that excluded him based on race. He argued that the Equal Protection Clause prohibits racial classifications and that the policy violated California's ban on racial discrimination. The Regents argued the program remedied historic exclusion and that diversity served a compelling state interest. They asserted that race was only one factor in a holistic process and that Bakke was not guaranteed admission even without the program. Next, we will look at the arguments and witnesses presented in the Bakke case. Let's review the background of the Bakke case and the initial legal findings. Alan Bakke, a qualified white engineer, was rejected twice by UC Davis, which reserved 16 seats for minorities. His lawsuit in federal court challenged the race-based quota. During discovery, a hidden memo revealed the school capped white applicants at 84, demonstrating a statutory quota. The district court ruled in Bakke's favor in 1975, finding the quota unconstitutional and ordering his admission. The case was appealed to the U.S. Supreme Court, resulting in the 1978 decision that rejected quotas but allowed race as a quote plus factor. The main arguments for Bakke focused on the unconstitutionality of quotas, which excluded him based on race. They argued that racial classifications violate the 14th Amendment and that remedying vague societal wrongs through individual discrimination is not a compelling state interest. We now turn to the key witnesses who testified in the Bakke trial. Alan Bakke, the plaintiff, testified about his high qualifications and repeated rejections due to reserved seats. His testimony emphasized that he was judged by his race, turning the structural debate into a personal story of injustice. Dr. David S. Woolley, Dean of Student Affairs, described the special admissions process. He argued the program was a quote plus factor, not an exclusion, and that white applicants were not barred from the general pool. Dr. Octavia Dorsey, a medical student admitted through the special program, provided a powerful narrative of overcoming systemic barriers. Her success proved the program worked by tapping into potential overlooked by standardized metrics. Dr. Thomas L. Stoddard, a UC Regent, framed the issue as the university's sovereign mission to train physicians for all communities. He argued that excluding minorities undermined the public health mission. We next examine the arguments and witnesses presented by the Regents of the University of California. The Regents argued the program was a narrowly tailored remedy for historic exclusion and served the compelling interest of educational diversity. They emphasized that a medical clientele reflecting the state's diversity is essential for culturally competent physicians. Here are some of the key witnesses for the University of California in the Bakke case. Dr. George Lowry, an alumnus of the special program, argued that diversity was essential for patient care and community service. His success countered the idea that affirmative action stigmatized beneficiaries. Dr. David S. Woolley detailed the admissions architecture, reiterating that the program utilized a lower academic threshold only after potential was determined. He defended the system as flexible and individualized. Dr. Octavia Dorsey provided an impactful testimony of overcoming disadvantage. Her experience demonstrated that the program successfully addressed societal inequality by bringing in qualified students whose potential was previously overlooked. Dr. Thomas L. Stoddard framed the program as part of the state's obligation to train doctors for a multiracial society. He argued that institutional diversity was critical to the university's mission. The district court ruled in favor of Alan Bakke, finding the racial quota unconstitutional under the Equal Protection Clause and Title VI, and ordered his admission to the medical school. The California Supreme Court affirmed the lower court, declaring the special admissions program unconstitutional under the 14th Amendment and ordering Bakke's admission. The Supreme Court issued a fractured 5-4 ruling. It struck down the rigid racial quota system, but held that race could still be a quote plus factor in admissions. Bakke was ultimately ordered admitted. The Supreme Court majority found the fixed quotas violated the Equal Protection Clause and Title VI. While striking down the quotas, they affirmed that race can be considered a quote plus factor for diversity. Justice Powell's swing vote was critical. He rejected fixed quotas as unconstitutional, but established that race could be used as one factor among many to achieve educational diversity, setting a key precedent. The Supreme Court dissent supported the use of rigid racial quotas to promote diversity and remedy past discrimination, arguing the court should defer to the university's judgment in this area. The Bakke decision struck down fixed racial quotas but solidified that race can be considered in university admissions to achieve diversity, establishing the quote plus factor approach. Thank you for watching this video on the Bakke case.